Hey, Kevin.
Hello, Rebecca.
Guess what we're doing?
It's got to be Readathon time.
It sure is.
So we had a big court hearing this is sort of the follow-up from the last court hearing.
Yes.
Where Judge Bev freaked the fuck out about something that the prosecution said, basically accusing the defense of lying at the original trial about witness testimony.
Right. Now, I want to say, unlike a certain hired prosecutor, I am happy to admit when I am wrong about something. Okay?
Yeah.
I was wrong about one thing we talked about in the last Readathon.
Mm-hmm.
There were a lot of questions about why it was that Bev suspended that hearing.
Mm-hmm.
And I said I was sure it was because of what the prosecutor said at that actual hearing. But other people thought it may have been something that happened during the break or whatever. It was because of what he said in the courtroom. So that's not what I'm wrong about.
Okay.
What I was wrong about was the fact that ARCA bill that was in dispute, that that he brought up and said came from the feds and all that stuff, I posited that was actually prep for the next trial. It was not. It was not prep for the next trial.
Okay.
So I want to switch the format up a little bit today while we're talking about this. And I know that you have questions going into today. So I'm assuming that your burning questions are the same as other people's burning questions. So I'm going to let you ask those and I will answer them. And then I will cover anything we don't talk about. Sound good?
Yeah, sure. So I mean, I think everybody was left from the last hearing wanting to know what made Judge Bev so angry.
Yes.
Did it have to do with what was represented by the prosecution about the bill from ARCA?
Right.
So, but we never heard from the defense. So what did the defense say about that issue?
Oh, boy. Okay. There's a long...
Is that just too big?
That's a big question. All right. So remember, Hank Brennan's issue that he brought up wasn't about the bill specifically.
Okay.
It was about what he said was a misrepresentation of the relationship between the defense and ARCA. Okay. He said that they represented that they had never spoken, that they had no relationship, that they didn't pay them, and that the witness said the same. Dr. Wolf, that's Crash Daddy.
Mm-hmm.
There's
Yeah,
Wolf and
Crash
Rentschler. Rentschler's the guy with the long hair. Wolf is the Crash Daddy one. And, that it was misrepresented, and that's why Bev got so upset. So, Alisi, by the way, I have been mispronouncing his name. It's Alisi, not Alessi. Robert Alisi, the new attorney from New York that was brought on, spent the majority of this hearing doing the talking.
Okay.
And the defense explanation for these files. Now, keep in mind, a huge issue at the last hearing was that Brennan said all of these files, this disclosure, the bill, the emails, this quote script for examination between Jackson and Wolf that they quote collaborated on or whatever, that all came, he initially said, from the feds. He had sent the feds what's called a TUI letter, and after lots of delays, they had finally disclosed all this to them. And so Judge Beverly Cannone was under the impression that the feds disclosed all this secret information to the prosecution. That is why she ended the hearing, and that's what he was asserting.
She thought that the feds gave it to the... Okay, right. Right. As opposed to the defense having the obligation to disclose it. Correct. And that they didn't disclose it.
Correct.
It was like, aha, we found a hidden thing.
Right.
Okay.
And
that's kind of what we got.
Right. But then right after the break, you might remember, he said very quickly, after she said to him, and this came up today, she said to him, you need to send me everything you got from the feds, as soon as you can. Mm-hmm. At which point he said, whoa, wait. I'm going to walk through a little timeline thing. And by the way, the emails I read didn't come from the feds. They came from the...
He walked it back. Some people caught that. Other people didn't. He
walked it back partly.
Okay.
He wasn't clear what material came from the defense and what material came from the feds. It all came from the defense.
Okay.
So let me just throw out to you a couple of things timeline-wise. There was a hearing on February 6th of this year that related to reciprocal discovery.
Okay.
They were talking about federal information. They're talking about apparently that 3,000-page document dump is all they've ever gotten from the feds, okay? They're talking about that, and Cannone asks Jackson, is there anything else that you're going to disclose? And he says, no, we have nothing else. He said in court today, when he was asked directly by the judge after the break, she actually asked the other attorneys questions. He said that he thought she was referring to federal materials. She didn't know he was referring to their disclosure materials. And so here's the timeline of events. In March of 2024, a long time before the trial, Alisi says it would have been malpractice if after seeing this ARCA report in the federal documents, if the defense did not reach out to them and ask them if they'd be witnesses at the trial.
Yeah, I feel like that would be a reversible error. Yeah,
right.
Yeah.
So in that March, so they had an email exchange, and that was the email that was called the engagement email. And basically, Jackson wrote to them and said, "I thank you for your phone call. I want to memorialize. We need to talk about an engagement letter. You can send it to me. Any retainer you might need, send it to me." And that was it. That was the substance of the email. Dan Wolf sent Jackson an email and said, I'll actually read it to you because what it actually said.
And Dan Wolf is from ARCA.
Yes. What it actually said is important.
All right.
Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it.
Okay, I get that. Yep.
So basically, the U.S. the feds were like, no, you just wait. We need to send you. We can't. Don't do this, right?
Right. Yeah. We don't actually know how we're using you yet. So we can't release you as a free agent.
Correct.
Okay.
Do you want to hear how Brennan read this exact email in court at the last hearing?
Okay. So we know. You just gave us...
I just gave you the verbatim.
Verbatim?
Yes.
What did he say as he's reading it?
He said to Judge Cannone that the email said, Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?
What did he miss?
He missed the whole putting a pause on further conversation.
Putting a pause on further conversation until we can receive additional information.
That pause is very important because basically what the defense is saying is they did not know until the trial was well underway that they were going to be able to use these guys as witnesses. Because at some point, like in early June, they got the all clear, you can use them as witnesses, and then their communication to arrange logistics and stuff picked up, okay?
Okay.
The night before Wolf testified, Wolf emailed the defense, Jackson, and he said, just talking about tomorrow's testimony, whatever, nothing weird. And attached to that was a document that said direct. It was like danielwolf.direct.doc or whatever. And basically it was
direct for direct examination.
Exactly.
Right, yeah, okay.
And there had been a lot of questions about their qualifications and the kinds of things they could talk about. And he basically sent a bunch of sample direct examination questions that he could speak to given his expertise. Okay. One of the details on there that's actually important is he said, one of the things I can talk about is nighttime pedestrian accident stuff, but you may not want to use that. That was like a smoking gun that Brennan kept pointing to as being they're coordinating. They're talking about what he's going to talk about, and that was misrepresented, okay?
Okay.
What Alisi pointed out was that, A, there was no coordination on this document. It was prepared by Wolf, period. And that not only did Jackson not use that outline in his direct examination of Wolf, he actually did ask the visibility pedestrian nighttime question.
Okay.
He stuck completely to what was in the report, and that whatever document he was sent did not enhance in any way what the direct examination was going to be. Okay. So that speaks to that. Now, the defense says that in mid-July, long after the Karen Reed trial was over, they received a bill from ARCA that they were not expecting to receive. It was out of the blue.
Okay.
Alisi says, I cannot share communications between attorney and client, but I can tell you there are communications indicating that this bill was a surprise. Okay?
Okay.
So immediately...
By the way, I probably would have sent a bill too.
Yeah.
If I've done that before, then I would do it in this case. Yeah.
Immediately, Alan Jackson, upon receipt of this bill and his knowledge of it, called the U.S. Attorney's Office and said, are we supposed to pay this bill? Like, I wasn't expecting this bill. Are we supposed to pay this bill? Is it okay to pay this bill? And they said, yes.
That they will pay the bill. The feds will pay the bill. No.
The defense will pay the bill.
The defense will pay. The feds say, we're not paying the bill.
Right.
So is the bill as far, I don't know if it's itemized, but is it?
It is itemized. So
is this for services rendered for the testimony, or is this to pay for services rendered for the testing and all that other stuff?
And that is what's at issue. It's for the testimony. It's time, travel, a prep for testimony that they did individually, and expenses like meals. Okay.
Yeah, which I don't think is like terribly out of left field for an expert witness of some kind.
And by the way, if they had paid for that stuff at trial, there's no reason why Jackson wouldn't say, we're paying you for So basically the core of Brennan's argument on this.
And I get why he made a big deal of it.
Right.
Because he couldn't say the feds retained you, the FBI, he was prohibited from mentioning anything about the FBI. So he tried to find a way to demonstrate the I guess the impartiality of the evidence, so just not any way they could get the jury to not think they were just hired guns. And we know that that's something that was important because when they questioned the jurors afterwards, all the jurors said that they had, questions about where these ARCA guys came from and to what extent they could believe them.
Correct.
Okay.
Now let me read to you from the transcript what Jackson actually asked the ARCA guy on the stand that everyone is remembering somehow as him saying, we've never had any contact before.
Right. Yeah.
This was what the actual...
And I've seen the clip, but I couldn't say it verbatim.
Okay. It goes without saying you haven't been paid by the defense. You have not paid us anything. No, 100% correct was the answer. And you don't work for us. That's correct. At the time, there was no retainer. There was no engagement. The only time they ever talked about a retainer or payment was that March email. And that had been all the way back in March, and they never talked about money again. Okay. And then they basically asked them, you don't work for us, correct? And then it was, at the time that you worked on your investigation and wrote this report, had we had any communication? Were we working together? No.
Okay.
And Alici's whole point here today was what was in that report, the initial report that came from the feds, was set in stone. Wolf and Rentschler never testified to anything different than what was in that report.
Right. They didn't create this report at the direction of the defense to imply that maybe it would go one way or the other. They're basically just using someone else's report. And again, we know why the defense kind of wanted to get that out there. And it almost seems like this wasn't necessary to talk about and disclose because the issue seems to be about what was represented here.
Right, exactly.
So if he just skipped over it, okay. Anyway, you're answering the questions.
This is Brennan's whole thing is it's not even that there is a bill. It's not even that they emailed about coordinating times and travel. It's that they represented differently. That's his whole thing.
Right.
And he was like, are we supposed to believe that the defense believed that they weren't going to pay these guys? The answer apparently is yes. They actually thought that they were on maybe federal time. They didn't know. Would Jackson have called the U.S. Attorney's Office if he didn't have a question about whether or not he was supposed to pay this bill? Like, why would he do that? And I will say he did. Alici did invite Judge Bev Cannone to just do the due diligence and call the U.S. attorney and find out if this conversation happened.
Right.
She said later in the hearing, she's like, I'm not going to do that. I'm not having ex parte communication. So she's not going to check on that, but that's what they assert happened, and they have apparently documentation and proof of that. So that's sort of at the heart of it. And then the other issue comes up at this February 6th hearing where Jackson said, I don't have anything else. And then they apparently did have this. And so what Alici is asserting is that even if Jackson did lie, which he says he didn't, and Jackson says he didn't, he said, I thought you were talking about federal documents. Even if he did lie.
Misunderstanding versus misrepresentation.
Correct.
Okay.
Even if he did misrepresent it, that is a completely separate issue than what Brennan is alleging should get Jackson kicked off the case.
Right. Okay.
Okay. So before I go on, what other questions do you have?
Oh, well, there was, and if this is getting out of order, let me know, but there was talk that the federal investigation has wrapped up.
Yes.
And what that might mean for trial number 2 and sort of the case writ large.
Right. There were actually 2 reporters yesterday, Ted Daniel of, I believe is a Fox 25, and Christina Rex. They both reported, Ted Daniel broke it, that 2 sources had told him that the federal investigation was over and that the feds had informed the Canton Police Department, the Norfolk County DA's office, and the state police that no charges were going to be filed. Christina Rex then said that she got, two sources, or sources had told her this, and that it was going to be announced in court today that the federal investigation was over. Interestingly, during the break today, reporters were asking Karen Read about this, and she said, I'm not sure I believe the investigation is over. And there was no announcement about it.
Yeah, right. Yeah.
So sources say, granted, is not always the greatest thing to report on.
Right. And just to point out that we're not 1,000% sure what they were investigating. Right. I mean, were they just looking into the Karen Read case, or again, were they looking at the DA's office and this got sucked into it? We know that there was the Sandra Birchmore case.
Was it a civil rights case?
Right.
Was it who knows?
Right. I mean, I also believe, look, if they're going to go to trial and charge Karen Read, then they don't have, the feds don't have a lot of options if they believe there's a different killer.
Right.
So they can't charge somebody else for murder that the state will just, is still going to say is someone else is the killer.
Exactly.
Yeah, okay.
So one thing that I want to mention.
So there's not a lot the feds can do except perhaps release their evidence. Exactly.
A couple of things I want to mention about this argument today that I found interesting.
Yeah.
So a couple of details came out. One is that Dr. Wolf sent Jackson that document the night before he was supposed to testify. Okay. Robert Alisi was like, are we supposed to believe that a defense attorney of Alan Jackson's skill level would not have already prepped his direct examination of a witness beforehand? Then he said, I'm going to speculate something here, which is based on my conversations with Jackson. This is what Alisi talking, that Wolf was nervous about testifying. He's never done this before. He's never testified for a trial for which he has not prepped with defense counsel in advance.
Okay.
And then Judge Bev Cannone put a pin in this, said, do not speculate.
Yeah.
If you can't prove it, don't say it. And he was like, that's fine. I'll tell you why I think this. It's based on my conversations with Alan Jackson. Okay. Remember that I said don't speculate in a second.
Okay.
All right. So that was an interesting fact. Another thing that came out, which I kept wondering why they kept bringing this up, this nighttime visibility expertise of Wolf, apparently, which was in this document that he had. I was like, why is this? Why do they keep bringing it up? And then I remembered at the previous hearing where all this came out, Brennan pointed to him saying that nighttime visibility, pedestrian accident expertise, he pointed at that and said, this would have been nice to have. Meaning that it was not reciprocally disclosed, this document, and so they didn't know that he had this expertise. Guess what?
What?
Wolf testified to that in the voir dire hearing in like April or whenever that was, that allowed that, or in June or whatever that was, that allowed the ARCA experts in. So they did have
that's right. I remember that because there was, as the trial was going on, they took a couple of days or whatever, like they did with the dog bite expert, to establish whether or not that testimony would be allowed.
Right.
And so you're saying that not in front of the jury, but in open court.
Oh, he said it again in front of the jury.
Okay, all right.
So basically,
so it's not a surprise. It's really not a surprise.
No, and Brennan kept saying this would have been nice to have. This would have been nice to have. They had everything that he testified to, and Alisi was basically like, I looked at the voir dire transcripts. I can't speak to other lawyers' strategy. I'm paraphrasing. But I may have asked more questions that they didn't ask. But the bottom line is
you mean the prosecution? Yeah, okay.
Lally. He did say, he said, so they can't claim they don't have that. They have it. And, he said that again at trial. Not only did he say it, but Jackson elicited that testimony. Because what Wolf actually said was, he's got lots of expertise in nighttime visibility, and there are more pedestrian accidents that happen at night because of visibility.
Yeah, sure. Yeah.
Which could look bad for Karen, right? But Jackson elicited that testimony because that's a big part of his expertise.
Okay.
Yeah. Any other questions you have?
So is there anything more about ARCA?
Yeah, there actually is.
Okay.
So ARCA is no longer being retained by the government. Their contract ended in
the federal government
in February. Okay. Right. Brennan asserts that it wasn't until after the feds said they had ended that contract that Karen's team finally disclosed these documents in this relationship, basically implying that they'd be able to cover up the relationship by having everyone assume that they were being hired by the feds when actually they were the ones paying them. Right. And it wasn't that. Basically, the timing of their release of this discovery to the prosecution had to do with another hearing that happened this month, which was about whether or not they were going to reconsider reciprocal discovery. So they were waiting for Bev's decision on that. I think that hearing was on the 6th, but the decision came out on the 12th. The reciprocal discovery stuff. She said she's not going to reconsider it. And so then they were like, all right, take this stuff. And for Brennan to, say that he didn't have it or that he thought it came from the feds, there is no way he could have thought that, because the email subject line said, Karen Reed, ARCA reciprocal discovery. And Bev Cannone asked, was there anything else in that email? And they were like, no, it only contained a link to these documents, the ones we're talking about. And interestingly, in a sort of cross-examination situation where Cannone then asked the other members of the defense team, like, what did you know and when? Elizabeth Little apparently told Alisi during the break that she completely forgot that March email asking for engagement stuff even existed. Like, they actually searched their email looking for anything related to ARCA, and that's when she found it and sent it.
Gotcha.
So that was really interesting. So can we talk about something else?
Absolutely. You're driving this bus, so you do it.
Okay. Brennan caused a big stink with Judge Cannone and this whole situation when he got up there and said the things he said.
Last time.
Yeah,
okay, sure.
Alisi, in his arguments today, laid out 10 specific lies that Brennan told on the stand. I'm not going to go through them, but he did assert several times that the document did not come from the defense. It came from the feds. He actually said this didn't come from the defense. It came from the feds. He was very specific. That it was all a ruse, and he said things about the timing that were just inaccurate, right? So he basically pointed out 10 specific untruths. And by the way, Alisi is very reverential, and he's like, I'm going to give
deferential.
I'm going to give Mr. Brennan the benefit of the doubt. He kept saying that until this part, because he was like, there's no way that he thought this. There's just no way he could have made this mistake, is kind of what he was implying. And then he had this very interesting passage that I thought was leading up to like a motion to dismiss with prejudice situation.
Right.
Where he said, he said this to Cannone, think about why you ended this hearing. It was because of the things he said. It was because he said this. It was because he said that. And then he listed like the 10 lies. That made you, reasonably so, very angry. You ended the hearing without allowing us to respond in any way. That went viral. And major news outlets, he said correctly, reported that we had been somehow caught out and that our defense team is in trouble. It went viral on social media. It was reported in the Globe. It was reported in the Herald. And what was not reported was that later Brennan kind of walked back his little stuff after the fact. Okay.
Yeah.
So he said,
you can't like fault the reporting for missing that. But I think he's making a point, Your Honor. We are entitled to respond to that, and you cut this short before, and because we weren't entitled, we didn't get the opportunity to respond to that. This went out there for a week.
That's right. And again, he pointed out that there's lots of prejudice in this hearing. Lots of prejudice was revealed because he read Cannone's comments. I'll see you in a week from today, and then continues and says this to Brennan. And where the federal authorities have allowed me to have copies of everything, can you tell them and ask for a copy of everything you just read? She said that to Brennan. Okay, saying that she absolutely received.
The judge asked the prosecutor that. Okay.
She absolutely received this material came from the feds. So what Alisi then said was, all of this happened. He was accusing the Commonwealth of doing this intentionally. He said, this is happening 6 weeks before the start of the next trial and as the juror letters are being sent. What are your thoughts on that?
Well, that's quite an accusation. I mean, is it unreasonable to assume that the government would do that? I mean, no.
I mean, he besmirched Jackson's reputation. He besmirched ARCA's reputation. I mean, that was not inconsequential. The motivation for that, right? The motivation for that is hard to say, right? I think it's going to come down to what your opinion is about the
the competency and whether or not this was in good faith or bad faith, right? But he's absolutely right. I mean, we rushed to do a readathon.
Just like we're doing today.
Right, just like we're doing today. Okay, certainly it's, we're not like influencing anything, but I'll just say that our observations was that's a big deal and we need to, and everybody covering it said the same thing. And I saw an awful lot on social media, especially the anti-Karen Read people really jumped on this. And they're like, it's
Jackson lied. They paid ARCA.
Yeah, it's like, what, Karen Read killed John O'Keefe, and then she killed Alan Jackson's legal career.
Exactly.
Yeah, right, absolutely. And the fact that it took, that they weren't going to get to respond for a whole week, yeah, that was problematic. Now, I don't know how the judge, fixes that, but anyway, you're right. It sounded like it was certainly leading to something. An ask.
That's right. What was interesting was...
They didn't ask those.
No, they didn't ask.
All right.
He talked about the prejudice at length, though, and then he talked about some Massachusetts rules, some conduct rules. Essentially, there's a rule saying that, attorneys can't lie in the court.
Yeah.
But if they do...
Not unreasonable.
If they say something that's not true, if they make a mistake, and Alicia kept saying, everyone makes mistakes. I make mistakes. It happens. If the Massachusetts Code says if an attorney makes a false statement of fact or fails to correct a false statement previously made to the tribunal by the lawyer, that is not allowed.
Right.
You have to correct it if you knowingly made a false statement.
Right. Otherwise, that gets usually reported to professional conduct committee.
Exactly.
This is how disbarment cases begin. Yeah, sure.
Another thing that Alicia
This is, by the way, is one of the reasons why in 2020, none of those lawyers were willing to go out and say, yes, there was fraud in voting.
Right.
They were there doing all the innuendo, but none of them wanted to put their law license on because they knew full well that they couldn't back that up.
Yes.
So yeah, okay. So, I mean, that's the same precedent. You can't lie. If you're a lawyer, you can't lie. There are consequences for
Absolutely.
Once. Okay.
Then he brought up the Sixth Amendment issue. And this spoke to the idea that Cannone might dismiss Jackson, take away his privileges in this case in Massachusetts.
Oh, okay, yeah, sure, right.
Because the Sixth Amendment says that you can have a counsel of your choice.
Right.
Okay?
Right.
And he talked about a case, a SCOTUS case, a Supreme Court case called Gonzalez.
Okay.
Where essentially a judge interpreted something that one of this guy's lawyers had done as being against a local rule.
Okay.
And disqualified that lawyer from the case. The Supreme Court later ruled with Gonzalez and said that was improper. And he ended up, getting a new trial or whatever because he was denied the counsel that he had chosen.
Right.
So that came up, and basically, again, Alisi said, if you perceive that Jackson made a mistake or said something that wasn't true on February 6th, which would be the only time that he said something that was factually untrue technically without...
Jackson said that.
That Jackson said it. And remember, Jackson says, I didn't intend that. I thought you were talking about federal documents.
Okay, right.
But,
so, yeah, okay.
But if you meant everything, then yes, I made a mistake, but that's not what I thought you were talking about. That if you perceive that, this Supreme Court case says that a local rule like this, that if he violated this local rule, you can't take away his ability to try this case in this state.
Yeah, sure.
Does that make sense?
Yes. Because again, what's at stake here isn't really about evidence in the Karen Read trial. This has all to do with the representation.
Right.
And really it is about all of a sudden, what was set in motion was now the defense has to save itself.
Right.
Not save their client, but save their ability to continue to represent them and not be sanctioned for something that never really happened. Okay.
Right. So, do you want to hear what Hank Brennan had to say after Alessi spoke for a couple of hours?
The prosecutor?
Yes.
Hank Brennan?
Yes.
Hammer and Hank Brennan. Yeah, what did he have to say?
He went straight to the Sixth Amendment thing first. And he said, I don't know what you're talking about me. Reed's team has done multiple violations. It's all I've been dealing with since I took this case, okay? And it was almost like you could tell Cannone wanted to be like what? But he shouldn't ask that. That's the thing that she would have asked Alisi, by the way.
Yes,
okay?
Probably, yeah.
And then he kept asserting that there's a, quote, murky relationship between the defense and the U.S. Attorney's Office and ARCA. He talked about that. He kept talking.
Yeah, actually, I don't know if it's improper, but yeah.
By the way, he kept talking about things being unfair. He kept using that word unfair
so
over
unfair.
and over and over again.
Been treated very unfairly.
He said he asserted that ARCA's opinions did change from their report and that they were biased.
Mm-hmm.
Now, keep in mind, Alisi said in his arguments, listen, you're not going to call an expert for your side that doesn't agree with your version of events, right?
Right.
So if you're going to call that bias, I guess that's fair, but like their opinions didn't change because we called them. Like their opinions were the same, but it's not bias. It's just what their opinions were. But if you want to call that bias, that's fine. But then you could say that all your witnesses were biased as well. Right?
Your forensic meteorologist that you want to bring in.
Right.
Okay, yeah.
And then his whole argument flipped to, you know what, Judge? It's not the source of the information. It's the substance of the information. Basically walking back everything he said, because it's all about the source, the timing, whatever.
Yeah.
It's the substance of the information. He talks about this relationship. And then guess what he does over and over and over again?
No idea.
Speculates.
Oh.
Without being told not to.
Yeah.
He didn't use the word speculation like Alisi said, but he said things like this. Maybe it's technically true that they never met face to face before that questioning. But I believe, and there's no way that there wasn't communication. There had to be. That was the substance of his argument.
Okay.
It's hard to believe they would come to Boston, they would do everything and send a bill later, thinking that they wouldn't be paid. I just don't believe that. There had to be communication. He just kept saying over and over and over again. He implies that they were lying about talking to the feds about whether or not they should pay the bill.
Oh, okay.
All right. He said
it seems they've already like laid it down. Go ahead and call the feds. They'll tell you this. Okay. Yeah.
Right. And essentially that there's just no way that they could be where they ended up unless they had conversations, and that the defense is lying about not having those conversations.
Okay.
Pure speculation.
Right.
No evidence as such, but she did not interrupt his speculation in any way.
Now, does the defense get to respond to those? Okay.
He got to do a quick rebuttal where he basically went through all of Brennan's points one by one.
Was this Jackson or was this?
It was Alisi again. Alisi did the whole argument today, and I'll talk about him in a second.
Okay.
And basically it was like...
Jackson was there?
Jackson was there,
okay,
Elizabeth Little was there,
Yeah,
Yannetti was there, and Alisi did the arguing today, which was
right.
a fantastic choice.
Mm-hmm. Yeah.
He just took apart his arguments one by one. He's like, he just said this thing that was again inaccurate. He just said this thing that was again inaccurate. One of the things that he said, Brennan said, was that, it proves that there was coordination between Jackson and these ARCA witnesses, because in an earlier hearing before the trial, Judge Cannone said to Jackson, "Are we to believe that you're going to bring 3 witnesses on without ever having talked to them about their testimony?" And Yannetti said, "Yeah, that's essentially true. We've only talked to them about coordinating time and stuff." Brennan says, "There are 3 people who wrote the ARCA report. How did they know which 2 to bring unless they had talked to ARCA, right?"
Mm-hmm.
So he's implying that this 3rd witness she's talking about is like another witness that they must have talked to. So when
as opposed to they picked 2.
Right. And when Alisi got up, he said, "Judge Cannone, if you look at the part of the transcript above and below what Brennan just read, it's very clear that the 3rd witness you're asking about is Dr. Russell, not one of the ARCA people."
The dog bite?
Yes.
Dr. Russell?
She was asking if they were sure that, is she supposed to believe that they'd bring in a dog bite expert and 2 ARCA people? They only ever requested the 2 ARCA people. I'm sure they looked at what their expertise was and like, these are the 2 most useful ones to our case, right? So he basically made up. He did this over and over and over again.
He's got a bad eye for detail if he's not being duplicitous.
He is, what is it called? Cherry picking.
Yeah.
He's clearly cherry picking. And Alisi was such a good choice to do this. His affect, he's very much like somebody on Twitter, I think it may have been Aidan Carney, said that he was like a high school teacher. He would do the substance of the argument and then say, this is why this matters. He was just like, here's what happened. This is why it matters. This is true. This isn't true. Let me read you from the transcript what it technically says. And then we can say, like, this is true, okay? He did the best job of pointing out the deceptive techniques of this prosecutor I have seen in this entire proceeding. Because one of the things that's obviously been frustrating me is that, the Commonwealth has just gotten up there and said things without facts and evidence. One of the things he pointed out was that Brennan brought all this stuff up at the last hearing without a motion and without an affidavit. He just got up and made a speech. And it is proper in these settings to submit a motion with an affidavit of fact, statements of fact, to argue. There was none of that. This was literally something he got up and sprung as a surprise on purpose to try to be disruptive, to try to do whatever. And he's just very, very chill in a way that is like kind of comforting.
Right. As opposed to Jackson's a little more theatrical.
Yeah.
And so you're saying he's a little more cerebral?
He's a little more cerebral.
Okay.
All right. So that's essentially what happened at the hearing today. Do you have any follow-up questions? Because I can move on to some news if you don't.
Okay. So when will we decide? Do we know when we're going to hear what comes out of this?
Next week.
Next week.
Yes.
There's another hearing.
I think there are 3 hearings scheduled for next week. I think it's like Tuesday, Wednesday, Thursday.
Okay.
And what's interesting was one of them is on the 5th. And Elise said, just so you know, regarding the 5th, we can't be here because we have an appearance scheduled in federal court that morning. Mm-hmm. You know what that appearance is for? Is
this continuing on the habeas corpus? Not the habeas corpus. On the double jeopardy.
It's a habeas petition.
Okay.
Yeah. So the defense filed a habeas petition with the federal court. Mm-hmm. Asking for those 2 charges her not to be retried on those 2 charges.
Right. This has to do with the jury having come to a verdict, but was not asked what it was before being dismissed.
Yes,
okay.
And a lot of lawyers that I have seen talking about this, more and more people are getting interested in this case right now. By the way, like a lot of legal types are saying that they should have asked for all 3. There's actually legal standing for them to have asked for all 3 of the charges.
Oh, okay.
But they didn't because they said an error such as the error that was made prejudiced the 3rd charge. The form that had to do with the form. It had to do with all that stuff.
Yeah.
There are a couple pieces of news though that I'd like to share with you that they're sort of extra this hearing.
Okay.
Also,
okay.
There has been a submission of a potential witness by the Commonwealth. And then the defense quickly filed a motion to exclude this witness. Okay?
Okay.
This is a forensic meteorologist that they want to bring in.
Okay.
And they specifically want to bring him in to talk about the hardness of the ground in front of 34 Fairview.
Okay.
Do you know why they would want that?
Because they have to explain the wounds to the front and the back of his skull.
Yeah. Basically, one of the theories that was floated at trial with nothing in evidence was that Karen hit John O'Keefe. He flew backwards, and the cause of his death, that damage in the back of his skull that caused all the trauma back there, was that he hit his head on the hard, frozen ground. All right? So in the defense's reply to this, their request to exclude him as a witness, which I'm guessing is not going to happen because Judge Cannone ruled on all the other stuff, like not in favor of the defense pretty much. Basically, they said, Mr. Gilman is not qualified to render the opinion on the subject of the hardness of the ground that he proffers. Neither Mr. Gilman nor the Commonwealth has put forth any information regarding Mr. Gilman's qualifications to testify as an expert about the ground's hardness and the requisite geology, hydrology, and other scientific precepts necessary to opine on the supposed hardness. The Commonwealth has failed to satisfy the methodology of the Dober-Lanigan analysis, yada, yada, yada. So basically, they're making the same argument that they've made about their dog bite expert, which is also that this guy is not a doctor. He's not qualified. So that's kind of the crux of that.
Yeah. I would wonder more about that evidence if there had been no snow on the ground. And he just hit frozen ground, but we know that
there was very
snowing.
little snow on the ground at that time.
Okay.
There was much more snow on the ground when he was found.
All right, so not enough to make a nice soft pillow of snow if you were to fall into it, but okay.
Right.
Yeah, and I'll just say one thing. It's like, okay, if you can determine, it's like one part of the equation. If you can say that the ground was hard, this hard, like then how do you then you need a medical doctor to say like, yes, that hardness, that's hard enough to cause this damage. The meteorologist isn't going to be able to say, yeah, that broken skull was caused by the ground being 27% hard. I don't even know how you measure that, but all right. Okay.
Exactly.
Okay.
Exactly.
Interesting.
Yeah, very interesting. Another thing that happened was, do you remember that I told you that the defense promised a, quote, full-throated motion to dismiss?
Yes, that's right.
That was due on Friday.
Okay.
Last Friday.
Right.
We have not seen it yet, but we do know it was filed because it's in the record of filings.
Okay. All right.
They did submit a motion to impound portions of their own motion to dismiss.
Okay, so meaning redact,
seal, etc.
All right. Portions, not the entire thing. Interesting. Right. Okay.
Right.
Why was that? Do we know?
They want to impound the portions of the filings that are subject to a protective order, including 1, reference to information that is subject to a federal protective order. 2, sidebar transcripts which remain impounded. 3, communications obtained from law enforcement witnesses that are subject to a protective order. I'm guessing that's, the text chain, the proctor stuff, whatever. And, good cause exists because they are subject to a federal protective order and because they just don't want that stuff out there for the public to
Right. So this is stuff that hasn't previously been made public.
Right.
They want to keep it that way for several reasons.
Right. All right. So a couple of other motions that were decided upon the last time we talked. The motion to reconsider reciprocal discovery was denied. Remember that motion? That was the one where they said that the Commonwealth was prepping witnesses using their reciprocal discovery.
Okay. Yeah.
That was denied. Another one that was denied was...
So reciprocal discovery will have to happen. She did not reconsider her decision. Okay.
Correct. A couple of them were denied that I'm not 100% sure what they are. They seem very technical. A motion for admission of Mark Betterow, that lawyer. Basically, what she said was the affidavit for that is insufficient and that Yannetti is going to provide more information that will make her make a decision on that. Their motion to compel video surveillance, the one that said, which provides in pertinent part that the prosecutor shall permit the defense to see all that metadata, that whatever, denied.
Oh, no.
Yeah.
Okay.
The motion to compel discovery, having to do, I believe this was discovery about the sources of stuff. Allowed in part, denied in part. 3 other defense requests denied without prejudice. Some of these were sort of technical, but clearly the defense lost the majority.
They can't get that metadata.
If not all of these. However, what's interesting about that metadata is that she today asked Alisi if she could see metadata on emails. She agrees that that's important.
Yeah.
Yeah. So one other thing I just want to mention, Beverly Cannone, despite all of her flaws, has a beautiful jade green Stanley Cup that she took copious sips out of during the hearing today. And it was just a very weird little human moment. Aside from the fact that...
Should I keep going to the bathroom?
After Alisi finished, she's like, I need to take a 10-minute break. And I was like...
We know why.
You know what? While you're taking that 10-minute break, Judge Cannone, I'm going to go take a 10-minute break too, if you know what I mean.
Yeah.
So, that's what happened today. And we're going to have plenty to talk about next week with these subsequent court appearances. I hope that we'll be able to talk about the full-throated motion to dismiss for government misconduct that was filed last week. We haven't seen it yet, but as soon as we do, we have to talk about it, among other issues. So, Kevin, do you feel like you have a sense of what happened today?
It seemed like it's a big day in court before the trial, and it seems like there's still more.
As one observer said during the hour-long lunch break, the Commonwealth has not left the courthouse. Hank Brennan is instead in a quiet back room eating his own words.
His own words.
That was the vibe. If you get a sense, that was the vibe.
Yeah, okay.
All right, well, we'll be back to talk about more. And Kevin, I can't thank you enough for joining me on this edition of the Readathon.
Oh, anytime, Rebecca.
Partners in Crime Media.